Right, so welcome to the first video on liability and negligence. And I'm going to refer to liability and negligence as either negligence or frequently tort. They mean one and the same things. Liability and negligence means tort law. So if you hear me talking about either of those, it means the same thing. And both of these are part of civil law. So we've crossed over now from looking at the criminal law, as we have been doing recently, to looking at issues of civil law. And I'll explain the difference and some of the differences anyway in a moment when we go through this. Now, I have to say that a great number of my students aren't huge fans of tort law, but I think it is fair to say that tort law has some similarities to criminal. I think it's ridiculously interesting. I think the cases, because it is case law driven, I think the cases are hugely interesting, and it helps us to practice and hone our case law skills, which we can apply to both criminal and tort law. So please look on it in that way, look on it as developing and continue to develop those same skills. But I personally think that tort law is a fascinating branch of the law, and certainly far, far more interesting than land law or equity and trusts. Sorry if you're a land lawyer or an equity and trust lawyer, but you know, tort, criminal has to be where the fun stuff is, I'm afraid. So let's have a look at about just what we mean. So I've got this picture here, because it makes me laugh, and it's continued to make me laugh for weeks and weeks and weeks. But the reason I've got that picture there is that that mullet is just wrong. That's it. And that's essentially what tort means. Tort is French for wrong. But it's a civil wrong. Not a breach of contract or a breach of trust, it's a civil wrong. And the purpose of that is to provide remedies when one person has been affected by another person's acts or omissions. And by remedies, we mean to put things right. So essentially, there is a civil wrong done to you. You are going to ask the law to put that right. You're going to ask them to put that wrong right through the process of a remedy. And that remedy generally takes the form of damages. Now, damages, if I'm honest, 9 times out of 10 involve money. And I'm going to look at a central principle for tort law and civil law in a moment. But just remember, it's a civil wrong for which you want to seek a right, you want things put right, and often the way in which that is put right is by financial compensation. It's not the only way by a long shot, but it is the most obvious and the most popular. The way in which we do that, the way in which we are able to demonstrate that there is a wrong, because that's the first thing, is that we need to demonstrate that there has been a civil wrong, is by applying the tortious liability equation. Now, I refer to this as the Holy Trinity, and I don't mean to upset anybody in any way by that, but it is the absolute, in much the same way that criminal law, if we were trying to prove that somebody was criminally liable, we looked at whether or not there was the actus reus present, then whether or not the mens rea was present, and then whether or not there was an absence of a defence. If all of those three things were in place, then we had criminal liability. I want you to approach tortious liability, and notice that I've sort of introduced a third element here now. So we've introduced the law of tort, we've got the law of negligence, but we've now also got tortious liability. Tortious liability can be proved by demonstrating three things. The first is that there has to be a duty of care owed to the claimant by the defendant. So you have to demonstrate that there is a duty of care, that somebody was supposed to do something for you. Once you have demonstrated that there is a duty of care, then you have to demonstrate that that duty of care is broken because the required standard of care has not been reached by the defendant. So if there is a duty of care and then that duty is broken or breached, that's the second stage. So the broken duty is referred to as a breach of duty. Our third element is called damage. note without an S, and I'll explain why that's important in a moment. Our third element is damage. And damage is about the broken duty or the breach, which must have caused the loss, and the loss must not be too remote a consequence. So in effect, this is the causation element. So our three elements to prove tortious liability is we have to demonstrate first, is there a duty of care? Second, has that duty been breached? And third, is that breach not too remote from the loss? If we have those three things, then we have tortious liability. If we don't have any one of them, then we have no tortious liability. So the equation works in pretty much the same way that the criminal liability one does. We're going to come back to each of these individually in separate videos where we'll be able to go through them one at a time and look at what constitutes a duty of care, what constitutes a breach of duty, and what constitutes a damage. And when we go on to look at the A2 and the LLB videos, we'll do these things in much greater depth and look at some very special circumstances around duty of care. So, let's go back to the civil law now. Let's have a look at what the civil law is for. Well, the civil law is about settling disputes between individuals. If I, for instance, well, I do own a home. If in my home, my neighbour decides that he's going to put up some of those awful trees, those ones that grow about 40 metres per day or something. Those, I think they're called Leylandi trees. And he does that across our two gardens. And by doing so, he blocks out all of my light, he stops my satellite signal, and he makes life pretty uncomfortable and horrid for me. He and I have a dispute. We are in disagreement about his trees. If I feel strongly enough and I cannot get him to take those trees down, I can go to law to ask that that dispute is settled. And by settling it, it means that we will be able to find a remedy to put things right and likely to have some form of damage. So the civil law is about settling disputes between individuals. Sometimes that can also be between businesses and government. So I should go down here actually. It could be about settling. So we could have disputes between individuals and businesses. It could be about individuals and government. It could be businesses to businesses, business to government, government to government, well, not government to government, government to business. But all of these areas are in the civil law. And the civil law is designed to settle disputes, whereas the criminal law is about punishing wrongdoing. My neighbour's trees is not wrong, it's not wrongdoing, it just happens to hamper my enjoyment of my house. That's a civil dispute. He doesn't need punishing for that. We just need somebody to decide whether or not a wrong has been done to me. If I decide to do that myself and go and knock on his door and punch him in the nose, then that would be wrongdoing, and for that I would require to be punished. In civil cases are started by the claimant. So the claimant starts a civil case. And the claimant is the person that has suffered the loss. They are sometimes often referred to as the plaintiff. So in civil cases, you have a claimant and a plaintiff. In criminal cases, of course, you generally have a victim. But in civil cases, you have a claimant or a plaintiff. But you still remain a defendant if you are being sued. You are still defending yourself, whether it's about a dispute or whether it's about a wrong, a criminal wrong. Okay? And the remedy, as we've already discovered, the remedy is generally damages. And by damages, we frequently mean cash. It's not all that we mean, but when we look at damages in another video, you'll understand that predominantly we're talking about cash. Now, I want to go back to something that I mentioned earlier on. Please do not get these confused. They are two separate things. If you look here, you'll see that the third part of our equation is damage. And damage is made up of causation and remoteness. That is different to damages, which is our remedy. So please be careful when you use the language. Damages is about the remedy. It's what you're paid to right the wrong. Damage is about the causation element of proving the wrong. So please get used to that sort of language. And that's going to take me to my key principle. This is something that all of my students can say out as a mantra. When they are asked, what is the purpose of tort? What's the purpose of civil law? But what is the purpose of tort? And the purpose of the civil law, the purpose of tort, is that damages should restore the claimant to the position they were in before the accident or the loss, as far as money can. Okay? So that means that I don't gain from anything, I don't lose anything by going to court. I should be in the position, I have been wronged, and if I have been wronged, I should be in the position, the same position, that I would have been had that wrong not have happened. Not better off, not profited, nor should I have lost, but my life should be the same if the loss hadn't occurred. So the key principle, commit it to memory, damages should restore the claimant to the position they were in before the accident or loss. I apologise for the poor spelling. So let's have a look at the civil process. And the civil process is the way in which a claim makes its way through the court system. The courts decide if a claim will succeed and what damages to award. And this can be, I've put this little slide here from Star Wars, this can be a long, complicated and difficult process. Some of these cases can get very complex indeed. And there are rules to say that this process should be speeded up as quickly as possible so as to make sure that people aren't inconvenienced, but nevertheless sometimes it can take a great deal of time. Once the claimant is advised that they are likely to have a claim, then their legal team collects evidence. So although it is through their legal team, in civil courts or civil cases, the claimant collects the evidence. In criminal cases, you'll remember, the state collects evidence through the police. Okay, so criminal, state collects evidence. In civil, the claimant collects the evidence, although that is predominantly through their legal team. Now, collecting evidence is easy for physical damage. If I have driven my car on the road and somebody has driven into me, they don't mean to do that, it was just an accident, but my car is damaged, it is easy for me to calculate how much damage has been done to my car. I take it to the garage, they take a look at it, they fix it, they give me a bill. It's cost £400. That's easy to quantify. That is not so easy to quantify for medical injury though, for instance. Let's say I've broken my leg in that accident and I have a bill for my car for £400. What I don't have is any understanding or idea about what the cost to the damage to my leg is. How much is that worth? How much is the pain worth? How much me not being able to play golf again for the next 6 months is worth? So gathering evidence is perhaps not quite so easy in civil cases or in tort as it might be in criminal. Once all that's been done, the two parties go to court for the issues to be tried and for an award to be calculated. So the courts then will try it and the courts will decide on the award. For many, many reasons, most cases are settled out of court. It is advisable and it is in the best interest of everybody concerned if tort or civil law cases are settled out of court, and most generally tend to be. The system, though, follows the rules of civil evidence. And civil evidence looks at how the facts must be proved and the degree of certainty. And to help us with that, I've got this little tiny flowchart which sums up what we've just said. We have an accident, we collect evidence, the case is prepared, and we enter into negotiations with the other side about what we think our damages should be. If we can come to an agreement, we settle out of court. If we can't come to an agreement, then we go to court. And we go to our trial court to prove that there was a duty of care, a breach to that duty, and that there was damage, i.e. there was causation. And then the court will give its verdict. Once it's given its verdict, it will then award damages. So, in that sense, we need to look at some clear rules of civil evidence. And the only thing I'm going to talk about really at the moment is this notion of the burden of proof. Who has the obligation to show the required degree of certainty? Well, you'll remember our old central tenet in criminal law was that the defendant is innocent until proven guilty, which puts the burden of proof on the state. Well, the same pretty much applies in civil law. The burden of proof is on the claimant. It is the claimant that brings the case to court that needs to prove that the defendant has a duty and that duty has been breached and that there is damage. So that's the burden of proof. The burden means that it falls onto the claimant. The standard to which the claimant has to prove that, so the standard of proof is what's known as the balance of probabilities. All right, so the balance of probability. You've probably heard that phrase before. So the burden of proof is on the claimant, and in civil cases, the claimant has to prove that burden of proof on the balance of probabilities. That's the standard. You will recall that in criminal cases, the standard of proof is beyond reasonable doubt. And beyond reasonable doubt, I'll just write it up here, beyond reasonable doubt, we said was about 99%. You've got to be about 99% certain. The balance of probabilities is more likely than not. More likely than not. It is more likely to have happened than it is not likely to have happened. And if you think about it, that's only 51%. 51 to 49 is on the balance of probabilities more likely than not. So there's a much lower standard of proof in civil cases than there is in criminal cases. And the reason for that is not about civil cases, it's about criminal cases. The reason for that is that there has to be such a high standard of proof in criminal because we are dealing with such serious consequences. We are dealing with people's lives, with their liberties, and therefore we have to be absolutely certain before we send somebody to prison, before we brand them a criminal. Providing we can demonstrate in civil that it's more than likely to be the case, then we are able then to give a verdict to the claimant. Now, the final thing to say is that in civil cases, juries are not used. So juries are not used in negligence trials. They take, so the decisions are made, the arbiter of fact and law, so the arbiter of both fact and law is the judge. And tort cases, civil cases, take place in the county court. We will do these when we do courts at the end. In the High Court Queen's Bench Division. All right, so that's where those cases are looked at. So that's given us a very quick and brief overview for civil law and an introduction to tortious liability. What we're going to do is I'm going to start now looking at each of these in turn. What do we mean by a duty of care? What is a duty of care? How do we prove it? How is that breached? What is the damage? So our next video will look at duty of care.